This is the American Law Journal.
Maybe it's always been there, maybe it always will be there, but what do Herman Cain, Penn State, and a U.S. Navy SEAL trial in Washington, D.C. tell us about sexual harassment in 2011? Good evening, I'm Christopher Naughton. Tonight we take a look at the hostile working environment and sexual harassment. Anthony Haller is here in the studio. He is the practice group leader for employment, benefits, and labor for the law firm of Blank Rome. Jennifer Hope joins us tonight. She's with the EEOC, the Equal Employment Opportunity Commission in Philadelphia, Pennsylvania. And Alice Ballard is with us once again. It's been a few years since we've seen Alice, employees attorney representing plaintiffs in employment matters. Well, whether you're for him or against him, when someone such as a Herman Cain or any luminary steps into the spotlight and the issue is sexual harassment, in some ways it's kind of the gift that keeps on giving, at least to those who are engaged in the practice of employment law.
I would think so, Christopher. Looking back, if you think about every decade, there's somebody that comes forward in the public eye, starting with Anita Hill, then Paula Jones, and now we have Mr. Cain. And that results in people becoming aware of the issue, us getting more questions, certainly from our clients on the management side, and I think then promotes claims and litigation.
Jennifer, do you find that to be the case after, again, some newsworthy event ties into sexual harassment, or it could be even gender discrimination? Do you find that there's a bump of calls at the EEOC? You're handling more sexual harassment cases?
I don't necessarily find that there's a bump in calls or even that we see a surge in charges. So what we look at is annual figures and annual statistics and annual filings. So, and as of now, EEOC recently released their annual enforcement statistics, and in fact, sexual harassment claims have declined, and they have been declining over the last decade, despite the fact that generally charges of discrimination have increased.
That connects to one of the interesting things that happened as a result of the Herman Cain situation, is that the Washington Post ran this poll and asked women and men, have you been the victim of sexual harassment, or are you afraid of being accused of sexual harassment? And the poll showed exactly what Jennifer was talking about, that actually it's getting better. It hasn't gone away, it's still a problem, but it's getting better. The percentage of women who said they've been the victims of sexual harassment at work has gone from the low 30% to the low 20%. And the percentage of men who are nervous or paranoid about that they're going to be falsely accused has also gone down from the low 30s to the low 20s. So women are safer and men feel safer, and that's good. And I'll tell you something, we owe it all to the women who come forward. Mm-hmm. So they get humiliated, we get progress.
Where I think the statistics may be a little misleading, the issues of sexual harassment today as they arise in claims are very closely linked to retaliation. And in fact, what we're seeing a lot more, and I think the statistics will support that, is retaliation claims, many of which are arising out of an underlying claim or complaint of sexual harassment. And it's the retaliation that's getting employers into trouble, not necessarily the underlying issue.
There are two sides of the same coin, sexual harassment and retaliation. You can't complain about sexual harassment without being retaliated against or without planning to be retaliated against. When somebody comes to me with a sexual harassment case, they say, should I make a complaint? I say, what's your goal? Do you want to keep the job? Do you want to preserve your mental health? Do you want revenge? Forget that. God has dibs on revenge. Can't have that. You want justice for other women at great personal cost. These are your options, and what you're going to do depends on which one you choose. But if you choose to make a complaint, you have to know what is Plan B when you get fired.
So when you get a case, and you take a case that involves sexual harassment, you're saying 90+% has retaliation involved.
You have to plan on it. If you decide you're going to make a complaint, you must plan on being retaliated against.
Right, you have to plan on it because in your experience, that's what happens.
That's what happens. I mean, first of all, maybe they'll say, oh, this is just he said, she said. Well, that's bad enough. Now you're a liar, right? Because nothing happens. You make the complaint and nothing happens because it was he said, she said. So that means you lied. If you manage to get the guy fired, his friends are all going to be mad at you. I don't think Anthony can show me a case where a woman has complained and been thrilled with the outcome.
Oh, that's a different question than I was expecting. I was going to ask him, I wanted him to answer that question, of course, but also, does every sexual harassment case that come across your desk also have retaliation attached to it?
Well, I think that from the management's perspective, it's a mirror image analysis, interestingly, having heard what Alice just said, which is that the complaint is made, and the first thing that you really have to do to advise the client is that you have to tell them that if they are going to do performance management, or if there's anything that comes up after the complaint is made that they think it warrants discipline of any kind, that they have to recognize that that may result in a retaliation claim. So it's like walking on eggshells, really. I've been through a lot of situations where a complaint has been made, there's been an investigation, the company has taken very firm action, they've after appropriate investigation concluded that the individual did something wrong and may discipline and may even terminate. And I think there are many situations where there's a proper and just resolution and that the person who's complaining is satisfied with the result. I do agree to some degree, though, with Alice, that more often than not there isn't a good outcome, which kind of brings you back to Herman Cain, because many of these situations get resolved quickly because people don't want the publicity, they don't want the reputational harm, they don't want to have to deal with the impact upon their families and their personal lives. And so there is a compelling interest sometimes of trying to just get the matter resolved that leads to settlement agreements or severance agreements, which apparently there's some lack of clarity as to which is which in Mr. Cain's mind.
Exactly, and get the terminology right, because I think he did say that he had engaged in a severance agreement or a sexual harassment agreement or something along those lines. He never said anything about a confidentiality agreement. He didn't have Anthony Haller in his corner, nor did he have the right publicist. But that's probably what should have been said, correct?
Well, I think, well, maybe. I think a severance agreement is more often than not a form of a settlement agreement. So I think the semantics really are not helpful here. Right. I mean, obviously there were claims made, there were settlements made. I'm not suggesting that the claims were valid or they weren't valid, but there was a resolution of those claims and it was supposed to be confidential.
Well, this is what Alan Dershowitz opined as to the confidentiality of this agreement. He said that once Cain spoke to the media, he may very well have waived a confidentiality agreement. It can't be the case that he can present his perspective and she can't. She is certainly entitled to answer what he has put forward in the media.
Every settlement agreement that, other than the ones the EEOC enters into, lucky them, but in the private sector, settlement agreements always have a confidentiality provision, either that says the amount of money is confidential or that says your whole story is confidential. And you can't tell it to anybody. And some of them even have provisions that say, if you do, you have to pay back part of the money. Now, nobody ever addresses in the agreements like this but there's an exception if your boss goes on TV and starts talking about you. We don't address that, but all of these private sector agreements do contain confidentiality provisions of some kind or another, and there's no getting around them. But Anthony is not going to settle a case with me, letting me have my client then have a press conference saying, I just got a year's salary because that guy pulled my head down towards his crotch. Mr. Cain. I mean, it's not going to happen.
There was a fascinating case in California where there was a sexual harassment complaint against the senior executive of the company. He was the owner of the company. And they settled the case, but they wanted to put on a reputational face to it. So they had a private settlement, but they agreed that they would go to an arbitrator, have the arbitrator reach a decision that essentially vindicated the individual. And that way they could pay the person, but also protect the reputation.
So that person had not only a lawyer, but a publicist.
Right. And they went with essentially an agreed arbitration award, and the arbitrator, the neutral, refused to sign it, and then the whole thing blew up. So it was a bad strategy. But it illustrates how important from the management side, the issues of protecting against disclosure of what has allegedly occurred, because even if it didn't, if it's said in public, it can be very harmful.
The EEOC is in a unique position in that when we do litigate a claim, we don't enter into private agreements. We file consent decrees, which are public because we litigate in the public interest. However, during the investigative stage, and this is a little contrary to what Alice indicated, where there's a reasonable cause finding after an investigation, the parties are provided the opportunity to come together to conciliate the claim, and in those instances, those settlements are confidential.
Confidentiality, again, is not an admission of guilt, obviously a criminal standard, but nor is it an admission of liability. And you couldn't operate in this arena, if I heard Alice correctly, unless you had that arrow in your quiver. You've got to have confidentiality.
Well, I think that if you don't have confidentiality, you remove a major pillar of the incentive to resolve the case. And then people will be more tempted to fight on because they want to vindicate their reputation. So that's the dilemma.
In the wake of the Herman Cain matter, everyone got involved. The New York Times had an op-ed piece not that long ago. Kathy Roife said this in the New York Times: recent parodies of the concept of sexual harassment hinge on a certain weakness or blurriness in the definition. The problem is, as it always was, the capaciousness of the concept, the umbrella-like nature of the charge. Sexual harassment includes both demanding sex in exchange for a job or a comment about someone's dress. The words used in workshops, uncomfortable, inappropriate, hostile, are vague, subjective, slippery. Sexual harassment, as they have defined it, encompasses a wide and colorful spectrum of behaviors. Is sexual harassment a moving target?
No.
And is it hard to pin down?
It's not hard to pin down. I mean, the Supreme Court has given us very specific definitions. It's got to bother the person. It has to be offensive to the person who's victimized. It has to be offensive to a reasonable person in that same position. It has to be severe or pervasive. It has to alter the conditions of employment. You know, this is what the Supreme Court has said. I don't know where she's getting her definitions, but that's the Supreme Court's definition. And it's not that easy a definition to meet. A few dirty jokes isn't going to make it.
Right, and commenting about what someone's wearing, even if it's revealing, one comment's not going to make it either.
Oh, no, one comment's not going to make it. And I'll tell you, there isn't a woman out there who's going to risk her job by complaining about that.
Right.
Why would she ever do that? It's always better to have a job than a case.
Is it safe to say that some women, although they don't welcome it, almost expect it to happen sometimes in the workplace, and it's up to them to take affirmative action so it doesn't happen again?
There are lots of things that people can do to try to make it not happen again. And you know, some women are strong and they can just tell the boss to knock it off. Some women are not strong, or they're very young or something like that, and they have to figure out some other way to make it work. But going to human resources and complaining about it is very rarely a good idea unless you're ready to lose the job.
When we return, what would you do if you were a woman doing her job and doing it well? A man makes suggestive remarks over and over again over a period of a few weeks and then plants a kiss on your lips. You complain to the boss, but the boss takes it out on you. We'll tell her story in just a minute.
This week's American Law Journal has been made possible in part by Blank Rome, providing strategic advice for employers in today's workplace. Scheller PC, protecting consumer rights since 1977. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.
In this case, there is no evidence that's been presented to the court that suggests that the burden on this particular individual to wear makeup was greater than the burden on men to comply with the rules that were imposed upon them.
Anthony.
And for that reason, clearly you lose.
Anthony, you know that it's unlawful to say women have to wear contacts while men can wear glasses. You know that. That's what the law says, and that's what we're working with here.
And there they are, negotiating, arguing, and engaging one another in civil discourse. Anthony Haller and Alice Ballard at the Union League a number of years ago. Have you folks ever squared off in, quote-unquote, a real court of law? You squared off quite well there in the debate.
We've had cases, but we've never been in court opposing each other on our feet.
All right, all right. Anytime soon, Alice? Anything coming up?
I think We might.
Stay tuned. Next program. And Jennifer Hope joins us tonight. Jennifer's with the EEOC in Philadelphia, Pennsylvania. And Jennifer, thanks for joining us. We've had a number of your colleagues join us here over the years. And in a nutshell, what does the EEOC do, and why is it so important for the consumer, for the individual employee?
The EEOC's mission is to enforce several of the statutes set forth by Congress. So Title VII, the Americans with Disability Act, the Age Discrimination and Employment Act. And the job of the EEOC is to enforce those through public outreach, through trainings, as well as through litigation, which is where I come in.
Great. Thank you for being here tonight. When we conduct programs that deal with employment issues, in fact, I think we ran a repeat not too long ago on retaliation. And of course, we get a bevy of phone calls and emails afterwards. Here's one of the emails that we received. I've been working on the job for a few years, and I've been doing my job well. Recently, an individual at my workplace has been making some provocative and harassing comments to me. One day he came over and placed his lips on my neck and kissed me. Now, I did not complain to the boss, but a friend of mine did. In the aftermath, the boss called me in and read me the riot act. What rights do I have? This is not an unusual fact scenario, Alice, is it?
It does happen that people get dragged into their own sexual harassment cases. That happens. And it certainly happens that the office pest does things like this, makes suggestive remarks, and then comes over and sniffs your hair and asks you what kind of shampoo you use and things like that. Yeah, that happens a lot.
This is really at the very beginning. Nothing has happened so definitively bad. There's nothing that's so pervasive here, or one particularly severe act, but we're getting close. So now, you disagree with
disagree with Alice
right.
and her view that it's not difficult to define. I think that it is difficult to define sometimes, because the conduct has to be severe or pervasive. Right. So what does that mean? And there's a test that has to be applied, and it's really a totality of the circumstances. So you never really know until you're looking backwards whether in fact it meets that test. And one judge or jury may view the conduct as severe or pervasive, whereas another judge or jury may see the same facts differently.
Well, I was playing judge for a moment, and I was saying there was nothing that was so severe or pervasive here. But again,
it's certainly something that would violate the company policy if they have one
Absolutely.
immediately. So you've got an immediate issue that needs to be dealt with. Somebody's complained.
All right, and I want to hear from all three of you. What advice, Alice, do you give the employee? What advice, Anthony, do you give the employer? And then Jennifer, you can chime in. Now, what does she do, Alice? She wants to keep her job. She is a performer.
That's the first thing. We go over what is your goal. How important is it? Do you need to keep the job? Do you want, at great personal cost, to make the workplace better for others? Or are you worried about your mental health and your sanity? And we look at your goals, and then we consider your options in light of the goals.
Let's say she wants to keep her job.
She wants to keep her job. She's got to square it away with this guy. She just has to deal with him on a personal level.
But now the Pandora's already out of the box. Someone's, not her, but someone else has now mentioned it to the boss. And now she's been called on the carpet for being a troublemaker. And I didn't read this, but it's in the email facts. It so happens that the perpetrator is also a good friend with the boss, who happens to also be female. Not that that's germane, but you've got a female boss, a female employee, who are now going at it because of what a male employee has done. So does she just tell, now what does she do? Now she just tell the guy to knock it off, and that's it?
Well, she has to tell the guy to knock it off, and she has to give, if she's trying to keep the job, she's got to give her boss the message. Clear as a bell, boss, my job here is to make you look good, and I am going to make you look good. That is my job. That's what I'm doing. I'm not making complaints. We're fine.
Right, gotcha. We're fine. But
we're fine. I'm here to make you look good. We're fine.
Message has been sent. Anthony.
Well, based on what you've said in the email, I mean, I think the company has a problem already, because somebody has complained, so they are on notice of a complaint. If they have a policy, they have to do something. So I would advise them that they need to do an investigation. So somebody in human resources would likely conduct that investigation, would meet with the person who made the complaint, would meet with this individual who was the victim of the alleged conduct, and would certainly meet with the individual who is allegedly perpetrated the conduct and remind them very clearly, as they would in each interview, of the company policy against retaliation, because what happened here is clearly a violation of policy and almost certainly is illegal retaliation. So you have to get control of that situation
and
right away.
one thing I did not bring up, because again, this email is rather lengthy, but apparently he kisses other women there, and they don't really, and the other women don't seem to mind. Again, I understand that that's not going to help the employer or the employee necessarily, but it's another piece of the fabric here.
One interesting thing about these cases when you get to trial is I found that juries are very hard on the women in these circumstances, that they really do expect them to engage in self-help, that if they don't immediately say something or do something and then later testify about an incident that maybe you know, in hindsight is fairly egregious, like the kissing on the back of the neck, juries are very judgmental about that and very hard on the women.
Interesting. That's interesting. Would you concur?
I think they are, and I think that, I mean, we've seen what has happened to Herman Cain's accusers. Anybody who speaks out, no matter whether it's the next day or 10 years later, gets dragged through the mud, humiliated, you know, jumped all over, credibility attacked, and that happens.
Anita Hill was still getting telephone calls just a few months ago.
Anita Hill, poor Anita Hill, and this happens to everybody who complains, and yet everybody who does complain generates an effect. Anthony then sits down with management and says, we have a problem, we have to do something about it. It's those women who complain and the personal cost that they bear, and half the time, more than half the time, they're going to lose that case. There's still going to be an effect in management with, you know, the advice coming from people like Anthony telling them, you got to have a better system. And at some point, someday, some management is going to get into some leadership.
And if they don't handle it, then the courts will. In the last year, we've seen some blockbuster jury verdicts out of Missouri, $95 million sexual harassment case, $15 million in compensatories, the rest in punitive damages. Now, yes, someone really got badly hurt in this matter, and I think the state statute would only limits it at $45 million. And here, a case out of Tennessee, a $1 million verdict. So you can get the ire of the jury up. Now, you're saying that, you know, sometimes juries are not real kindly to the women, but does it boil down to this? It's really not about the two players per se, it's what management doesn't do after they've been told, right? That's why they end
up merging into retaliation cases.
Yeah.
And because every time a complaint is made, whether ultimately it's justified or not, whether it meets the severe or pervasive standard or not, it's sufficient to be protected activity. And if something then bad happens to the employee, discipline, bad performance review, demotion, termination, then you have a retaliation case. And it's the retaliation cases that I think really get juries mad, and that's where you get those multi-million-dollar verdicts.
Last question from the panel, to the degree you feel comfortable answering this question. Is there, let me know if I'm fishing too, is there a thread among some of the things that we've seen in the news lately, whether it's the Penn State issue, or certainly more pertinently the Herman Cain matter, or this trial that's taking place in Washington, D.C., 28 women have filed, no, it's actually 28 plaintiffs, some are men, have filed sexual harassment claims against the U.S. Navy.
That's the Chico versus Donald Rumsfeld case.
Yes, right.
I mean, from my perspective, Christopher, I mean, although Alice and I disagree on a lot of things, as you can tell, I think that all of us here on the panel would agree that the things that have occurred with respect to sexual harassment, from the original Supreme Court case in Meriter to Anita Hill, to the events that are taking place today, have been very sanitary. That is, people have been much more aware. Employers have taken action. I mean, one can criticize individual employers, but in a general sense, people have policies, they do training, and they've really made a difference in the workplace. And to come back to the Chico case, what I think is really interesting about that case, when you read the complaint, and it's only a complaint now, and it may not go anywhere because of the rules about whether you can in fact sue the military and issues of immunity. But putting those aside, when you read that complaint, it is startling. And it's startling because it involves not just comments in the workplace, it involves actual allegations of sexual assault and rape, where there's been complete inaction to remedy the situation. I mean, that's something you cannot contemplate in private employment generally anymore. May have existed one day because there is recourse. And I think it's a very stark contrast between the strides we have made in an environment where the law does operate, where the EEOC does operate, where people like Alice operate, where good employers have good policies and take them seriously. Compare that with a situation where there really isn't, a set of strict laws and recourse that's available.
I mean, I hear what Anthony's saying, and I hear the statistics. Things are getting better, but some of the problems are still in those old male bastions.
They're in the old male bastions, but to me, especially with the Navy SEALs case, when you read the complaint, I agree with Anthony, it's horrifying. It's rape after rape after rape. And then the really horrifying part is there are the allegations that Congress had demanded that the Defense Department do something, develop criteria, develop statistics, develop a program, and they didn't. And to me, I think the next steps that we need to see in the area of sexual harassment is better leadership. If you have good leadership, then, if you have a good message coming from management, then you're not going to have the kind of atmosphere that gives men permission to protect each other, to close ranks around the people who complain. It gives them the feeling that they can bet their jobs on retaliating against somebody because the environment is, they're going to be safe. And with leadership from the top, which is what that Navy SEALs case is talking about, is pointing at, that's the way we're really going to keep moving forward. More cases, bringing to light more lack of leadership.
To bring it back to Herman Cain, I think that there is clearly a tendency for institutions, and I include large private employers and medium-sized private employers in that definition, when they are faced with something that could be very embarrassing to the institution, to want to come together and protect the institution. So quite often people think only of the moment. How do we deal with this situation in the moment? And they don't look down the road and say, well, what happens later on if this all comes out? And I think we've had instance after instance of situations where, the people that are making the decisions have made it based upon their view of what's best in the moment, but then when that's played out down the road, they haven't really taken enough steps to really dig in, find out what's going on, how endemic is it, and then they've sort of really failed to take, in retrospect, proper steps to correct the actions.
We are here every week dispensing legal advice, talking the law. Tonight it was sexual harassment and the hostile working environment. If you have more questions, go to our website, American Law Journal TV, or simply Law Journal TV. Check us out on Facebook, tweet us, Twitter, American Law Journal. Go to the website, get your law on demand. I want to thank my great panel tonight, Anthony Haller for the defense for the corporations with Blank Rome, Jennifer Hope with the EEOC in Philadelphia, and Alice Ballard, a private practitioner representing employees also in Philadelphia. For all of us here at the American Law Journal, until next Monday night, case closed.